All rise. Supreme Court of Oklahoma session. Honorable Chief Justice Robert J. Thornton presiding.
Afide, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA25-005, People of Guam Plaintiff Appellee versus Joseph L. Pugh Jr., Defendant Appellant. Appearing for the Defendant Appellant is Attorney Levan Titano Camacho. Appearing for the Plaintiff Appellee is Attorney W. Lyle Stamps. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Camacho reserves 3 minutes.
Mr. Camacho, you may proceed.
Chief Justice, may it please the court. Mr. Pugh was beaten unconscious by between 5 to 12 individuals. He suffered broken ribs, broken orbitals, and a chipped tooth. At trial, he was convicted of 3 counts of aggravated assault for the people who beat him unconscious. This appeal centers on whether or not the jury instructions provided by the trial court accurately stated the law of self-defense as applied to the specific facts of this case. We contend that the trial court made 4 errors. The first was it did not accurately instruct the jurors on how to apply the concept of provocation. The second is that the trial court completely failed to instruct the jury on the ability of a defendant to regain the right to self-defense. The trial court also failed and deprived the jury of determining whether or not there was non-deadly force or deadly force used in the encounter. The last error we've alleged, Your Honors, is that the trial court also erred to instruct the jurors on how or on who bore the burden of proof with respect to the limitations of self-defense and the concept of self-defense.
I'm a little confused about your court argument, Mr. Camacho. I'm sorry, can you hear me?
Yes, Your Honor.
So when I looked at the transcripts and reviewed again the jury instructions that were given on the issue regarding the burden in proving that the defendant did not act in self-defense, there were a series of instructions that I thought illustrated that duty pretty clearly when you read the instructions as a whole. And we can start with the instruction 1E. Just permit me to just summarize these instructions and why you feel that these instructions as a whole does not adequately clarify the government's burden on this self-defense. Instruction 1E, the burden of proof in self-defense. I don't need to read what the instruction says, but the important point there is that the jury must acquit the defendant if people failed to disprove that the defendant acted in self-defense beyond a reasonable doubt. And then when you read that in conjunction with 5A, consideration of each charge separately, and then instruction 6K, especially the second paragraph. If you could just, we focus on the second paragraph there of 6K, which references for each individual charge, the trial court included the requirement that the prosecution must prove beyond a reasonable doubt that the defendant did not act in self-defense as an element of the offense. And finally, the use of deadly force as a defense, limited instruction 6M, where the use of deadly force is not justifiable under jury instruction 6K, the self-defense that proceeds on to track the statute. So when I look at those 4 instructions in particular, in reference to the issue that you raised, on the fourth argument, it seems pretty clear that the jury were informed as to what their duties are in reference to the government's burden of proof as to the self-defense instruction, and if the government didn't prove that the defendant acted in self-defense and must acquit. They specifically use that as opposed to Gargarita, where you successfully argued that those instructions were convoluted.
Yes, Your Honor. I understand that the test is looking at the jury instructions as a whole. As Your Honor was reading jury instruction 6M, I believe, which deals with the limitations on self-defense. So Your Honor is correct that the jury instructions accurately stated the government must prove beyond a reasonable doubt that Mr. Pugh was not acting in self-defense. It also provided instruction 6M, which specifically states that self-defense is not available if a defendant, as an example, provoked the use of force. 6M then, so if a jury under that instruction were to find that the defendant provoked the use of force in that encounter, the government would not be required to prove or disprove self-defense.
Right.
And 6M does not speak to who has the burden of proving provocation. It does not speak to who has the burden of potentially regaining the right to self-defense. So that's where we're at, Your Honor. We have to concede that the trial court did provide the instructions in Cotto that the court found were adequate in light of Gargarita. But once you go through the limitations on self-defense, a jury with these instructions would not have even reached self-defense if it found provocation. So that's where we are, our last argument.
But isn't that the law, that if the defendant provoked the encounter, that then they are not entitled to the self-defense instruction?
Yes, Your Honor, that is an accurate statement of the law. But the question is, who bears the burden of proving provocation? And we submit that the law requires the government to disprove or to prove beyond a reasonable doubt that a defendant provoked the use of force.
But isn't there a separate jury instructions in reference to the burden of proof that the government must prove beyond a reasonable doubt each element of the offense? I didn't read that instruction, but I recall that instruction was given. Does that address your point that the jury was not separately or not sufficiently informed as to the burden of proof?
When you look at what the actual elements of the offenses that were given to the jury was on or about in Guam, the defendant did recklessly cause serious physical injury to and did not act in self-defense. So those were the only elements given with respect to each of the charges and counts. And what I'm saying is, if you were to read those elements in conjunction with 6M, the jury could have found that Mr. Pugh did not act in self-defense if it believed he didn't disprove that he didn't provoke the fight, Your Honor. So that instruction could have been given, but the problem is that there was no instruction to the jurors that, one, it was the government's burden to prove beyond a reasonable doubt that Mr. Pugh provoked the fight. Two, that it was the government's burden to prove that Mr. Pugh provoked the fight with respect to each victim. And that's where factually, if your honors look at the convictions, the first charge, the most serious charge, the second-degree aggravated assault, was against a victim who wasn't even present during the initial encounter. The most serious charge was for injuring someone who joined the fight after it already started. And what we submit is that if the trial court had properly instructed the jury that the government needed to prove beyond a reasonable doubt that Mr. Pugh did not provoke the fight against JJ, there's no way based on this record it could have found so, because he wasn't even present when the fight started.
Under our law, there's also the use of force towards a person is justifiable to protect the third person. So how does the doctrine of defense of others, the tension between that and this idea of you have to require the initial aggressor and provocation?
Your Honor, if JJ was charged with aggravated assault for beating Mr. Pugh unconscious, then I believe then that instruction would be given. But I don't believe that is relevant when. So that is its first situation. Again, if JJ, and using the facts of this case, the victim, were also charged criminally with beating Mr. Pugh unconscious and breaking his ribs and breaking his eye socket, then he could raise that he was acting in self-defense, not directly, but on behalf of a third party. So I look at that as a defense that's raised by a defendant.
So you think that only applies if the person is charged?
That's correct, Your Honor. I don't believe that it would remove the obligation of the government. So provocation, again, it makes sense that if I start a fight, I can't claim I was acting in self-defense. But even under the government's witnesses, there's nothing on the record to suggest that Mr. Pugh started a fight with JJ at all. Nothing. And for him to be convicted of aggravated assault, I think the standard was under circumstances manifesting extreme indifference to human life. It was the highest grade of aggravated assault for someone who joined the fight after he, based on the government's witnesses, was being swarmed by between 5 and 12 people. If the jury was provided an accurate instruction on provocation, there's no way they should have found him guilty of that offense.
You brought up JJ. Was JJ the only person who was assaulted after retreat?
I believe, Your Honor, the chronology is that it was Mr. Fiachosi who was everyone agreed the testimony was that was where the initial encounter was. And I believe even Mr. Pugh testified that he was having words with someone. And there is a factual dispute as to whether or not when SP, the second victim, I'll call them, was injured.
But I mean, even if we agree with you that Mr. Pugh may have regained his right to self-defense upon withdrawal, that wouldn't apply to all of the victims in this case, right?
I believe that's accurate, Your Honor. And under that situation, then our third, one of the errors that we have alleged is that the trial court completely failed to instruct the jury to allow the jury to find, as a matter of fact, whether or not Mr. Pugh used non-deadly force. The trial court essentially found as a matter of law that he had employed deadly force, which has different standards. And I believe, Your Honor, for regaining the right to self-defense, provocation, none of that is actually included if the jury were to have found that he was using non-deadly force.
But how is that different from the jury being instructed on deadly force, applying it to the facts, and if the jury found that he did not administer deadly force, then they may have concluded that it was non-deadly force that was used, and that they were not instructed to convict under those circumstances. In other words, they were instructed as to what deadly force and how it applied to the separate charges and the limitation where you can use deadly force as a defense. You track the entire statute. The jury hears that, concludes that deadly force was not used in the manner that provided a self-defense, or in the manner that self-defense did not apply. So why would that not be sufficient when the result of that is that they then, I would assume, found that non-deadly force was used? What would have the instructions added to that analysis?
I understand Your Honor's question is saying, well, the jury was instructed on deadly force and limitations on deadly force, and if the jury didn't find, they believe Mr. Pugh used non-deadly force, then what would happen? I think that's the point, Your Honor. The instructions don't provide the jury with any guidance as to what they were to do if they were to find, as a matter of fact, that Mr. Pugh employed non-deadly force.
Well, didn't the fact that there were these series of not guilty findings suggest that they did understand that if they didn't find deadly force, that therefore Mr. Pugh is not to be held accountable for those specific counts and charges?
What I would submit, Your Honor, is that the jury instructions don't provide the pathway to get to that result. And that may have been, they would have had to have gone beyond what they were instructed to arrive at a result where they are finding Mr. Pugh not guilty of an offense if they did not believe he used non-deadly force. They did, there was a special allegation of use, and if Your Honors look at the transcripts, the victims themselves were not consistent in terms of what was used during the assault. It was a metal pipe, something like that. And then Mr. Pugh, of course, testified that he used like a tent rod to defend himself. But we would submit that the first question is whether or not the trial court could have found as a matter of law and deprived the jury of the opportunity to determine the level of force that was used. And from that would flow, again, provocation is not part of the analysis when you get to self-defense for the use of non-deadly force, regaining the right to self-defense. So the analysis would have been completely different. I think even necessity, potentially, I think it just had to be commensurate if it was the standard non-deadly force instruction. But getting back to the question that Justice Torres had asked, even if you were to look at the provocation and specific to each of the victims and the different facts that would apply, the burden of proof issue is one, and again, the deadly force completely changes the analysis for the jurors. If they were to have found non-deadly force, then the provocation becomes a non-issue. Then the restoration of the right to self-defense becomes a non-issue because the jury found non-deadly force. It's like, okay, were you acting reasonably? And we would submit, again, in the facts of this case, where you're outnumbered 1 to 12, a jury could have found that that was reasonable to defend yourself with whatever was nearby, which is what Mr. Pugh testified to.
When you suggest that he withdrew in self-defense, then became possible again, was it just to the defendant, I'm sorry, the victim JJ, or was it to the whole group at that point?
And again, Your Honor, I believe that clearly with JJ, that it should have been, it would have been restored, that the jury could have found that was restored. With SP, the second victim, that really would have been a fact for the jury to determine when the injuries that were alleged to have occurred happened. So SP testified that he got up and was approaching, and then all of a sudden he was hit in the back of the head with what he believed was a metal pipe. But the jury, if I believe Fiotosi was the one who said that he was already backing up, and it was SP who then blocked Mr. Pugh from leaving. So that is a factual determination that the jury should have made, whether or not, if Mr. Pugh was trying to retreat and was blocked off and then tried to defend himself, at that point self-defense would have become an issue and would have been valid against SP as well. I'll continue. Thank you, Your Honor. So we've talked about provocation. We've talked about the ability of a defendant to regain the right to self-defense, as well as the use of deadly and non-deadly force. Now, the government has relied on the jury instructions that Justice Carbolito pointed to, but that still doesn't solve the problem of the burden of proof. And this is a situation where the statute alone doesn't accurately explain to the jurors what their function is and how they are supposed to apply the laws to the particular facts of this case. If you were to look at the jury instruction standing alone, even in the totality, there is nothing in the jury instructions that show or instruct the jurors that the government was required to prove beyond a reasonable doubt that Pugh was the initial aggressor for each of the victims. There is nothing in the jury instructions that require the jurors to find that it was the government's burden to prove beyond a reasonable doubt that Mr. Pugh used deadly force. There is nothing in the jury instructions alone that explained to the jurors that it was the government's burden to prove beyond a reasonable doubt that Mr. Pugh did not regain his right to self-defense at some point. There is nothing in the jury instructions that explains to the jurors that it was the government's burden to prove beyond reasonable doubt that Mr. Pugh's belief that the force that he used was necessary to protect himself. So all of these are basic self-defense principles, starting with the government's burden of proof, and none of that was conveyed to the jurors if you were to examine the jury instructions, even as a whole.
So you don't, you still contend that, instruction 1E, where it specifically says that the people have the burden of proving beyond a reasonable doubt that the defendant did not act in self-defense and must acquit. If the people fail to disprove that the defendant acted in self-defense beyond a reasonable doubt, then it proceeds with the other instructions in relations to considering each charge separately, and instructions for each charge. And then again, the use of deadly force and its limitation. So it starts with what the people's burden is, and I, at least as I read instruction 1E. So why does that not address some of the concerns that you're raising?
Yes, Your Honor. I think it goes back to when the trial court provided the limitations on self-defense only with the limitations for the application of deadly force. That's where we contend there was error. All of these arise out of that. And that when you provide, we concede that that is what the statute says. The defendant isn't justified in using self-defense if they were the initial aggressor. But that statute doesn't lay out the burden of proof. So what we contend is there was no explanation. If 6M said the government is required to prove beyond a reasonable doubt that one of these limitations applies. Beyond a reasonable doubt. That potentially, I can see that would have explained to the jurors as you're reading through, self-defense doesn't apply if A, B, or C, and it is the government's burden of proof. It is the government's burden to prove one of these exemptions or limitations beyond a reasonable doubt. Because then you can read it in conjunction with self-defense. The standard, you must acquit if you believe the government did not disprove self-defense beyond a reasonable doubt. So what we're arguing is that it's the limitations, that the same burden of proof for disproving self-defense applies to the limitations of self-defense. The reason why I was pointing out that these are not new concepts, and we've cited to, and I know Justice Carvalho doesn't necessarily believe in the persuasive authority of other jurisdictions' jury instructions. But in light of Gargarita, Gargarita and Cotto really stand for the proposition that it's the trial court's responsibility to accurately state the law. It's not a very complex, this is what the trial courts are required to do. They did not do so in this case. I believe that we can all agree that it's established that if you provoke a fight or your initial aggressor with one victim, you haven't forfeited your right completely if you were subsequently attacked by multiple people, which is what happened here. It affected Mr. Pugh's substantial rights because that was the central defense, was self-defense. And the jury was deprived of the ability to properly make a determination as to whether or not the limitations applied, whether or not there was non-deadly force. And just as in Gargarita, there was a very high likelihood that the jury could have come out the other way. It could have acquitted if it was given the proper instructions. So if the panel has no question.
No further questions. You have 7.5 minutes left.
Thank you, Your Honor.
Mr. Stamps.
Chief Justice, Your Honors, may it please the court. Like to pick up exactly where your questions had led us previously. just to refine and make a few more points on that, and bring some of the record out to help flesh those discussions out. Other than that, I'll go through those points, and then panel has any questions, or obviously if the panel has any questions at any time. First off, I want to, in the strongest possible way, refute this notion that the trial court didn't do its job. The trial court did exactly its job. It followed this court's precedent to the letter. Now, as
What about on the issue of provocation, that there was no instruction to say that they had the burden of proof to prove that he was provoked the fight?
yes, Your Honor. And that's where, if we go to instruction 1E, 1H, 7A, 7B, 7C, D, F, G, I, J, L, M, O. Each of these, in each, and it's replete. I mean, basically, it's like saying the trial court instructed the jury that the people always have the burden of proof. Prove beyond a reasonable doubt,
Yeah, but
always.
instruction 1E doesn't say anything about provocation.
And you're correct, Your Honor. It doesn't say anything specifically about provocation, but it does say the burden is always upon the prosecution. Always.
I don't think Mr. Camacho disputes that. That's a general proposition.
That's the general proposition, and then the court brought it out as to each separate charge. Each separate charge. Anytime the jury was going to, so I think defense counsel is bringing up that, well, we've got 3 separate victims here. And the order of events, it's a little challenging because, well, we don't have any facts to determine what that order of events is really, right? We have some basic testimony. Some of it's conflicting, some of it not. For example, the first individual who was there, Mr. Fukosi, defense wants to point to his testimony that the third person, JJ, was standing behind and preventing him from leaving. Well, if we're going to credit that testimony, then we also have to consider that witness's other testimony, which was that the defendant unilaterally initiated the conflict by taking a weapon that he was already carrying and hit him. So I find it difficult to where we're taking, the defense wants to use one part of the witness's testimony and not the other. I think that's highly problematical. But so we've got we have 3 separate victims. Fine. They need separate jury instructions. Absolutely. There were separate jury instructions for each one of those separate defendants. The jury was more than adequately instructed over and over again that the burden lies with the people. If we look to the instruction on self-defense, self-defense 6K, self-defense is a defense to the charges. The people have the burden of proving beyond a reasonable doubt that the defendant did not act in self-defense. You must acquit the defendant if the people fail to prove that the defendant acted in self-defense. That includes provocation. And that was repeated over and over and over again. So I commend the trial court for following the instructions of this court and adequately laying all this out for the jury. If perhaps defense counsel also wanted it included in 6K on the deadly force also, maybe that would be ideal to have that each time. However, when it's already been repeated 19 times, I think that's probably sufficient in this case.
What about regaining the right to self-defense upon withdrawal?
Yes, Your Honor, that's an excellent question. And again, the challenge there is the sequence of events and the timing. We don't have sufficient facts of record to determine how is it that the defendant withdrew. The defense didn't even provide a standard by which you can evaluate how you would, a legal standard under which is not hard to find, under which you can regain that right. There's not a case cited under Guam law or another court that the defense has provided as to how that happens.
But wasn't there testimony that he withdrew or attempted to withdraw and then was blocked and then?
That was one, that was the testimony of one witness and the defense. Right? Something important to keep in mind here, I think, is that we do have some conflicting testimony. According to all of the witnesses on people's side, except for the defendant approached these teenagers, and a few were adults, and he initiated the conflict with 2 blows, attacking the first 2 victims. And that, as defense counsel pointed out in his argument earlier, that he mentioned that Fukuyoshi got up, right? Meaning he was sitting down when he was initially attacked. So how is it that the defendant was retreating from this pack of people that supposedly he felt threatened by when the first person that was hit, undisputably, was sitting down? That doesn't make sense. It's not logical.
Well, it wasn't with regard to the first or even the second victim. I think it related to JJ.
Yes.
And that's why I had asked the question, if he did regain his right to self-defense or had attempted to withdraw and regained his right to self-defense.
Yes, and as to that point, Your Honor, and defense counsel would be absolutely clear about that, right? About that also. The people have the burden. We always have the burden each time. So if facts are presented, however, that's the problem. The defense did not really provide any evidence on that part. And if there is no evidence to support the jury instruction or defense, even if we the people bear the burden on it, if there is no evidence to support that jury instruction, then it's not supposed to be offered. People versus Root 2005 Guam 16, paragraph 28. Now here, as to JJ, as has been brought up, he's the only person, the only charge, that third person who allegedly that third person may have joined the fight afterwards. They stood behind and they prevented the defendant allegedly from retreating. Okay, well, retreating from where? It would be extremely helpful, I think, for the trial court and for everyone to see, well, how far was that? I think it makes a huge difference. If the defendant retreated from here to that, took back 5 steps, that's one thing. If the defendant, after those first initial blows and the 2 victims were struck, and then he suddenly realizes, oh, shoot, I've got 4 guys here that I decided to attack, and they have some friends nearby, and then there's more friends over there in the corner there, and now suddenly, oh, shoot, I did something really stupid. And he runs out that way. That's one thing. But even in that instance, I'm not sure he regains the right to self-defense. Now, in order to determine that, it would be really helpful if, for example, the defense had presented, well, it'd obviously be really helpful if this defense was presented or suggested or developed before the day of trial, for example, but it wasn't. For example, I would suggest that we should look to other jurisdictions that have dealt with this issue, such as the federal courts that have had to deal with this repeatedly over and over again. The Second Circuit, in the case of United States versus Desenor, 525 F3rd 193, Second Circuit 2008, said that as to the self-defense, if someone's going to regain that self-defense defense, there's 3 steps. Number 1, the defendant had, quote, withdrawn from the confrontation. Number 2, communicated his withdrawal to the victims. And 3, the dangerous situation that the defendant created had dissipated. Here, and we can only guess again because the defense didn't provide this information to the trial court. They didn't have that evidence because there was no evidence presented at trial to support those. Did he withdraw from the confrontation? Maybe. It says that there was some testimony that he backed up. He was trying to get away. But did he communicate? Was there any communication? Did he say, "Whoa, guys, sorry about that. I slipped. I didn't mean to hit you," or "I'm feeling threatened. Just leave me alone"? No, zero testimony to that effect. So no communication. So three-part test. You need all three in order to regain that right to self-defense. First prong met? Maybe. Second prong? Nope, absolutely not. 3, the dangerous situation that the defendant created had dissipated. I don't think that the dangerous situation here dissipated. Obviously, the victims and their friends felt threatened. And that brings us right back to JJ, right? The third victim. Because, as the Chief Justice pointed out, under 9 GCA 7.88, force in defense of third persons, that there's an absolute defense if you believe that you need to use force to defend another person, then under the statute, you're allowed to do that. You're allowed to do that in using such force to protect yourself against the injury that you believe to be threatened to the person that you're seeking to protect under A1. So JJ had an absolute legal right to step in. So the defense says, well, no provocation is proven. No, absolutely provocation was proven, because we may not, the people didn't bring up at trial, it wasn't said, well, JJ had the right under 7.8881 to step in, but the facts were there. The law doesn't have to be explained, I believe, every time when the facts are present. JJ stepped in to protect his friends. He thought his friends were threatened. And under his testimony, that's what he saw. He saw someone walk up to his friends after having left previously. So again, the victim's testimony is the defendant was there, was belligerent, hostile, told them to leave. They felt threatened. And then he comes back and starts hitting them.
What about the argument that Mr. Camacho raises, that because there was no non-deadly force instruction, instruction 6M regarding the use of deadly force as a defense was not sufficient, and as I understand it in this way, that instruction 6M says that the use of deadly force is not justified if the defendant, with the purpose of causing serious bodily harm, provoke the use of force against himself in the same manner. So we have this provocation language in 6M that he is not justified in using deadly force if he provoked. However, as I understand it, the jury was given the instruction on non-deadly force. And so even if he provoked the use of force, then that doesn't disqualify him from being, that doesn't disqualify the individual from using that non-deadly force, even if he was the initial, if he provoked the encounter, and that he is still then entitled to a self-defense instruction.
Yes, absolutely, Your Honor. And both of those, between jury instruction 6K on self-defense, and then yes, there was a limiter given in 6M. The use of self-defense is limited if it involves deadly force. Jury was also instructed as to what deadly force is in 6L. So the jury had these instructions. The jury made the factual determination.
Yeah, but the jury was not instructed as to the use of non-deadly force. That's the point.
Because I submit that they didn't need to be instructed as to use of non-deadly force, because if the limiter didn't apply, if 6M didn't apply, the jury determines that, okay, Jury goes through this and says, okay, deadly force doesn't apply in this situation. 6L, we look through this, we know what deadly force is. They make the determination if there's deadly force or not. If they make the determination there's no deadly force, then they go, okay, well, then we don't need to go and look through here at 6M. So we're going to go back to 6K, which I would submit is the jury instruction or use of non-deadly force. That's the standard instruction. So if the jury determined there was no deadly force, then that's their determination, their factual determination to make. Then they default back here to 6K, where again, it instructs them, the burden is on the people to prove that.
But if they concluded that the non-deadly force was used, but still the language of provocation that you provoked, then it's not justifiable. That seemingly is suggested by 6M, and that is where I think Mr. Camacho is saying that there may be some confusion in that regard.
And given the totality of the instructions, Your Honor, I don't see how that a reasonable jury could possibly have that issue. I think the instructions are well laid out, and when they go through them one at a time, even if they skip the order a little bit, they're going to, it funnels them to reach the correct result as to each, whether there was deadly force or not, whether or not there was self-defense, right? If the defendant provoked, then he doesn't get self-defense. That's pretty clear. If he didn't provoke, and again, the burden's on the
But if
people
he
either way.
provoked and he used non-deadly force, then there's nothing to say that self-defense is not he's not entitled to a self-defense result under the self-defense instruction. That
It gets my apologies, Your Honor, I think it gets a little, ends
Yeah,
up
that's
getting a
what
little
we do.
convoluted, right? I think it's very clear to the jury here. The use of force upon or toward another person is justifiable when the defendant believes that such force is immediately necessary for the purpose of protecting himself against the use of unlawful force. If the defendant provoked the incident by attacking, by being the first attacker, well, then it doesn't qualify. That's not lawful force. You don't get to just walk up to someone and start hitting them. That seems very logical and rational for, I think that's just the jury seeing the instruction and following it through after making their evaluation of the facts. One. As to the three-part test earlier that I provided, that was, I know that the site was in 2008. However, that's also was used recently, United States versus Barnes. The first case was the Second Circuit. This was the 10th Circuit, and this was back in May of this year. So this is a test that has been used extensively. We've got good 15 years of use on it, and that is used by the federal government in their trials to determine when that right to self-defense is regained after they're determined. I respectfully submit that even without that formalized legal test, all of that is rational, logical analysis that the jury can have come to based on the testimony and the facts that they evaluated. And because the defense didn't provide any facts to the contrary, they didn't provide any facts that would suggest that if he's going to regain his right to self-defense, again, did he withdraw? Did he communicate his withdrawal? And did the dangerous situation lapse? And the facts show that facts do not support that. And if the facts don't support it, then he's not entitled to the jury instruction.
But if his withdrawal was blocked, as you could view the situation as he
And
was
as
unable to withdraw at that point, even though his actions made it.
Well, that's an interesting point, Your Honor, and I appreciate you raising that as to JJ, our third victim, comes up to help and supposedly is blocking this person. Are you really blocked? Is a 40-year-old man blocked by a teenager? One person's behind him and suddenly he can't run away. I'm sorry, but you don't, again, we're not the jury, we don't have the defendant in front of us to physically evaluate it, but I'm really struggling to see how one person blocked the defendant from running away. If he wanted to get away, if he wanted to retreat, he could have done so. I don't see how any other rational or reasonable result could be reached from that. Would the teenager have a weapon? No, there's nothing stopping him from running away. I think it's important to keep in mind also that the standard here, Your Honors, I'd respectfully submit that what we're dealing here is plain error, which is highly prejudicial error requiring the appellant to prove an error occurred. Okay. Perhaps they've raised that there might be an error. It could have been done better. We could have put additionally in there something about provocation and burden of proof 20 times instead of 19. And that it was clear or obvious under current law. I think we're running into a stumbling block there because the defense hasn't cited to us clear or obvious current Guam law that says this is how you retreat, this is how you regain your right to self-defense. The defense is asking for new law to be built and to be made here. Granted, as this court pointed out, and Gargarita wrote, sometimes that has to happen because of the age of the court and jurisdiction. We don't have case law on every situation. However, I think we need to ask ourselves, is this the case where you want to try and make new case law on whether or not someone has the right to retreat when the defense couldn't even provide a framework to do that to begin with? Did it affect the defendant's substantial rights? I respectfully submit it didn't affect any substantial rights. The defense provided their evidence, the people provided theirs. The jury evaluated that evidence. The jury were properly instructed on the law. They reached their result. And 4, reversal is necessary to prevent a miscarriage of justice or maintain the integrity of the judicial process. In this instance, it looks like it would cause more harm and create more problems with the judicial process to try and fix this problem after the fact. Defense counsel was in charge of their trial strategy. Defense counsel chose to go, all right, let's throw up a self-defense. Not an unreasonable choice when you don't have a defense because all the other witnesses are saying that you provoked it. The jury could have determined that defendant was more credible than all the other witnesses. Okay, and the defense didn't object to that. Did the defense ask for it? Did the defense say, hey, Your Honor, here's some jury instructions that will cover how to recover the right of self-defense. Here's some jury instructions or some law to cover how we should take provocation in this instance. No, none of that happened. All of that was waived.
If there's nothing further.
No, Your Honor, I think that those highlight the points that I had. I see that there's some time and I was going to reserve that for any rebuttal regardless. So thank you, Your Honor.
Thank you. You don't get a server rebuttal, but Mr.
I'll give you
Camacho,
3 of my minutes back.
7 minutes left.
Thank you, Your Honor. I just want to go through. Mr. Sampson's right, we're not the jury. Jury instructions aren't supposed to be convoluted. They're not supposed to be technical. They are supposed to relay legal concepts to jurors in a clear and accurate manner. Now, during the government's presentation, I didn't hear a recitation of what the law on provocation actually is. And whether or not it's their position that if you provoke with one, you have forfeited your right to self-defense. But going along, when he mentioned, and Justice Carbolito talked about 6K. So if you read 6K, it talks about self-defense, it defines self-defense in the last paragraph, does clearly explain that you must acquit the defendant if the people fail to disprove that the defendant acted in self-defense beyond a reasonable doubt. So let's assume that we are the jury, and we find that the government has failed to disprove that the defendant acted in self-defense beyond a reasonable doubt. Under this, we have to acquit. Then we get to 6M, which expressly says the use of deadly force is not justifiable under 6K unless the defendant believes that such force is necessary to protect himself, and it goes through what, nor is it justifiable if the defendant with the purpose of causing death or serious bodily harm provoked the use of force against himself in the same encounter. So a juror walking through these instructions could have found the government failed to meet its burden, was prepared to acquit, and then gets to instruction 6M and says, you know what? The government keeps saying in closing, Mr. Pugh called it upon himself. He caused this. It's his fault. Under this instruction, 6K doesn't apply. And that's really where our argument centers on. There is nothing here that explains to our jurors who has the burden of proving provocation. And with respect, so on provocation, and as you read through the instructions, if we were to put ourselves in the position of the jury, even assuming that were to occur, it doesn't talk about how the provocation has to be with respect to each victim. We haven't really talked about that. Regarding the test for regaining the right to self-defense, there was no instruction. None. The government has said there was no evidence. The government's own witnesses provided the testimony that Mr. Pugh was attempting to back away, was blocked, and then was beaten until he stopped moving. He cited to the Second Circuit, we agree on the test. He cited to the California criminal jury instructions, which our statutes are derived from, and it goes through, the same. It's actually a two-part test. One, did they in good faith try to stop fighting? And two, did they indicate by word or conduct? And I think that's really where, if you're backing up and trying to run away, do you have to say, hey guys, I don't want to stop fighting? I don't believe the law of self-defense requires you to tell someone if you're trying to run away and they stop you and continue fighting with you. And when that happens, when you are by word or conduct trying to stop fighting, or you have stopped fighting, then you can continue to fight because you are now defending yourself against the person. And so we keep trying to kind of fix the law. The laws on Guam are okay. It's the jury instructions that we're giving to the jurors to explain those concepts is where we fall short. And instead of trying to recreate the wheel, we do have all these other jurisdictions that have laws that are similar to ours that we can tap into. But this is what happens, and this is what the government's position is. Well, that's the law. If that's the case, then if a court were to just give the Guam Code annotated and let the jury deliberate, I think trial courts are required to do more than that. And I would submit that's exactly what this court has held in Margarita and affirmed in Cotto. The trial court's job is to explain to the jurors how to apply their function, to accurately state the law. More jury instructions necessarily isn't better. I would prefer one clear instruction versus 500 ones where you're having to piece together all of these. So we keep encountering these issues, and it's because we fall into this cycle of giving the statute without actually trying to instruct the jurors on what they're required to find. And that's, the court needs to determine what is the law on provocation. What is the law? We haven't had cases that really go through this. And then the question is going to be, well, did the trial court accurately explain it to the jurors? And I would submit no. The trial court did not explain, it got the law right, but it did not explain to the jurors specifically what the limitations were, when they applied. They gave them the law and without any guides as to how to apply the law, which is what the trial court's function was. So unless the court has any issue.
Is there any evidence he did not provoke? What can you point to that says he did not provoke the fight?
Your Honor, I I think with the first victim, it's very hard for Fiatrosi to, based on the testimony, but I'd say for the second and third victim, at best, the jury should have made the determination whether or not there was provocation. I think for the first
Isn't that when defense of others comes in?
well, I believe, and maybe this is where I don't believe the court has given instruction on whether or not, but I just don't think if I start a fight with one person and then I'm attacked by two, does that mean that I can't defend myself against the other two? I don't see the defense of others coming into play for my ability to defend myself against these other two who have joined the fracas. So if you charge these people with assault, yes, they can say, well, I wasn't initially attacked, but someone else was attacked and I was defending them. I don't believe that goes to whether or not if I attack someone, then I'm attacked by a bunch of other people, whether or not I can argue self-defense against those people who join later. So I understand, and that's where I go back to, if there was a factual question as to whether or not the initial encounter, there was the use of deadly force, then provocation doesn't matter. And it's not a limiting factor, and you just go back to the regular concept of self-defense. And the jury, again, was not provided that instruction or that ability.
If the defendant didn't have a weapon of some kind, that's more understandable, but he had a weapon in his case.
Your Honor, and I think that's really where that is going to be a credibility issue, because I believe Mr. Pugh testified, he showed up, said something, words were exchanged, and then it was only after the encounter had started that he picked something up off the ground. The victims testified that he was carrying something, but even then they were not consistent across the board as to what happened and what he used. I mean, I think it's pretty clear it was a knife, it was a pipe. I mean, it changed depending on the victim. So at best, it was a fact that should have been determined by the jury, and then also in terms of sequence. But if they believe he showed up, was talking, and then got into a fist fight, the provocation wouldn't have mattered, and he could have claimed self-defense. Thank you, Your Honors.
Thank you, Mr. Taitano. Thank you, Mr. Stamps. The court will take the matter under advisement.